Good morning, everybody. Thanks for joining us. This is the third in a series of four webinars on natural capital issues. I'm Penny Simpson and I lead the natural capital legal team at Freeth. We're a team of seven disciplines across the firm and approximately 30 senior lawyers. Three of us are here today. That's myself, Penny, Kirsten Roberts and Gareth Forty. Kirsten's a commercial contracts lawyer with a specialism in natural capital issues, and Gareth is a real estate lawyer equally specialised in natural capital and Habitat Bank issues. This webinar's on brokerage and allocation agreements, and it's focused on people who would like to become brokers or are interested in setting up a business doing this, and to help them know what they need to know to do that kind of work. Next slide, please, Tom. As I mentioned, this is the third of four webinars. The first two webinars took place earlier in September and October, and the recordings are available on the link that we've given you there. The fourth one is on the 21st of October, so please, 21st of October, so please do sign up for that again on the link below if you'd like to. And the agenda for this morning is, first of all, just to give a little introduction into the direction of travel for natural capital, where we're getting the drivers for people who need to buy nature-based credits. And that's something I will deal with. And then I'll pass over to Kirsten and Gareth, who will look at commercial and contractual issues relevant to brokers, both in brokerage agreements and under allocation agreements. So just a little bit about why we have a nature markets and how also we can incentivize people to invest in nature markets. There are a number of compliance regimes in our country which allow there to be a demand for nature credits and nature-based solutions. These are very simply provided on this slide here. We have, of course, biodiversity net gain, which is currently in place under the Town and Country Planning Act, and that is driving the need for biodiversity units. We also have the forthcoming biodiversity net gain regime coming under the Planning Act for nationally significant infrastructure projects. We're hearing that that's going to be May next year when that comes live. So we can expect a bigger demand for biodiversity units once that gets going. We also have, of course, existing regulations that protect species and also certain designated areas for conservation. And these have driven some need for credits, both in terms of nutrient neutrality credits, so nutrient credits. Those tend to be nitrate or phosphate credits, and in some cases, credits for protected species. That regime is to do with offsetting impacts, not restoration, whereas BNG is to do with nature restoration. And there's also a less formal compliance system, but nevertheless a system of drainage and wastewater management plans which apply to water companies. And there is an incentive to consider nature-based solutions in that context. So these are the sort of what I would perhaps put as or describe as compliance drivers or near compliance drivers to nature markets at the moment. We have, of course, the Nature Restoration Fund, which is being talked about under the Planning and Infrastructure Bill. There's not a picture, there's not a bubble showing that here, but that is a future possible driver for nature markets as well. Next slide, please, Tom. And we also have, of course, voluntary-led markets, and this has come from really two angles. The first three bubbles underneath the word nature are to do with the Climate Change Act and the need for net zero, and that has led to a need for various codes to buy offset carbon impacts, and that tends to be considered in relation to nature-based solutions through the three codes that I've mentioned: the peatland code, the woodland code, and the saltmarsh code. So there is a demand for nature-based credits to address net zero through that system. We also have, and this is the interesting bit, the Environment Act and the EIP, Environmental Improvement Plan 2023, which is being updated now and is due to be published later this year. So we're expecting an EIP 25. And we're being told that that EIP 25 will have more clarity over how the Environment Act targets will actually be met. So we have all these targets that require restoration of nature. The targets need to be implemented, and we hope the EIP 25 will be clearer on how the implementation will take place. And that could become another driver for nature markets. So we really hope that does happen, because we need nature markets, because we need to incentivize private investment in nature. And only through that mechanism will we actually deliver nature restoration, which is so badly needed in this country. Okay, thank you. Over to Kirsten then.
Thank you. Next slide, please. Thank you. So just to start with the basics, the audience for this, we're assuming, is mainly intermediaries. So there is going to be a landowner who may also be the seller, the buyer, who's normally a developer, whether they're developing warehouses or houses or old people's homes. But as Penny mentioned, we expect in the future some of these buyers to be part of the voluntary scheme rather than the mandatory compliance scheme. And then you, the broker, sit in the middle. Next slide, please. So there isn't a one-size-fits-all type of brokerage arrangement. We've seen all sorts. So we've tried to give you some examples here, because depending upon how much you want to get involved in the sale of the units or credits from the seller to the developer, and what your appetite for risk is, will depend which of these you take from. So I would suggest you see this more of a menu that you can pick and choose from. So just to give you some ideas, therefore, some brokers are literally what I've called hands-off. So they introduce buyers and sellers and take a commission. So in that circumstance, you might have a brokerage arrangement with the seller under which you take your commission, and or with the buyer under which you take some commission, but nothing else is happening. But what that means is you don't have to pay for perhaps your own legal fees in assisting a seller to negotiate Section 106, etc., in order to create these units or credits. But also then you're not in charge of that process. You don't know when it will happen. You don't know if the seller's going to back out, just delay. If the seller is a farmer, they may be distracted by more important matters such as crops or animals. So that's where I say that it's a cost risk, because the more you reduce your risk, the more you may be increasing your upfront costs. I'm going to talk about costs later on. So the slightly more hands-on approach, you may be negotiating the Section 106 on behalf of the landowner. Of course, it's the landowner that has to enter into that Section 106, but Gareth's going to come back to that. You may be negotiating the allocation agreements, which is what we call the sale agreements, between the seller and the buyer. Some intermediaries get a bit confused and think that they are selling the units, but you don't own them. The landowner, the party that enters into the Section 106, or in the case of biodiversity net gain units, the conservation covenant, they own the units, but you can facilitate that arrangement, but you're not selling them yourself. And then it gets even more involved, where you might be providing some of the land management services, either yourself or subcontracting those to a third party to provide them. And that can be the original enhancement works that create the unit credit in the first place, and or the ongoing management monitoring works that need to be done on the land under the planning documents. Again, the Section 106, or for the NG, the Conservation Covenant. And at that point, Gareth, can I hand over to you, because you get involved when it's even more involved.
Yeah, of course. Thanks, Kirsten. Yes, so as the note says, alternative model is where the broker takes the land interest. So the broker may wish to take responsibility for the whole scheme, from establishing the feasibility of the site to negotiating the Section 106 agreement or conservation covenant, dealing with the allocations, and thereafter establishment and management of the habitat site. And for that purpose, generally they'll take a lease. So why would they use this model? This model will maximise the returns to the broker, who will ultimately receive a larger proportion of the credit sales. But in return for that risk, they are responsible for the lifetime compliance. And the landowner in that model will take an initial share of the sale proceeds only. And it's suitable where the landowner requires a very hands-off approach. The issues with that as well is the landowner is likely to need to be a party to the Section 106 agreement in order to bind the interests of the landowner. And in that scenario, the landowner is likely to be concerned about compliance where the lease could be terminated. And in those instances, you may be discussing security deposits, bonds, or other arrangements to give comfort to the landlord. And then Further beyond that is where the buyer or developer takes the interest themselves. So they may want to secure a site for themselves to allocate for their own developments and then sell any excess credits for themselves to the wider market. And then further left field from that is where the developer takes an option to call upon the landowner to enter into a Section 106 agreement, for example. In that scenario, the developer does not take a land interest, but will have the benefit of an option agreement to call upon a landowner to enter into a planning agreement to provide off-site mitigation. It's more common in nutrient neutrality issues. The benefit of this will be a one-off payment to the landowner, and the developer is not responsible for the management of the mitigation site. And back to you now, Kirsten.
Thank you. Next slide, please. So as you can see, lots of different models. Some things we'd recommend though. Firstly, in your brokerage agreement with the landowner, always include some form of an exclusivity clause and contractual restrictive covenants, because what you don't want the landowner doing is appointing you to go and sell units and credits on its behalf, but also either appointing somebody else to do it or doing it itself. And that's because, well, firstly, it's all going to get a bit confused, but secondly, it's going to reduce the commission that you can earn on those sales. So you need a bit of control over that. You may want to go further in terms of protecting your position and insist on the landowner registering a restriction on its title. Gareth, back to you on that one, because that's a real estate issue.
Yes, thanks, Kirsten. Yeah, so the longer the brokerage agreement is to endure, then you'd want to then have some protection to ensure that that contractual commercial arrangement will bind the successor in title. So by including a restriction on the title, before they can sell the property, they would effectively have to novate or enter into a covenant with the new owner. So the new owner then is bound with the arrangement they'd already made with the broker.
Thank you. And as Gareth mentioned, whether or not you're going for those additional levels of protection will depend on how long you expect this agreement to last. So some brokerage arrangements we see are very short. They're going to be 12-month agreements. Of course, that doesn't mean that the landowner won't sell the land in that period. But others we see may go on for 10 years or more, in which case, you know, lots of things might happen to that freehold title and you'd want some control. Because even though under the brokerage agreement, you would have a contractual remedy if the landowner sold and the new owner wasn't complying, your contractual remedy would be against the old landowner. Have they got any money? Have they all moved it all offshore? So that's where you'd be thinking about trying to bind the land as well in order to protect your position. Next slide, please. So again, as I mentioned, there isn't a one-size-fits-all model, and therefore this is a very generalized idea of how the share of the pie works effectively. But you, depending upon how much involvement you have in the creation of the units and credits, well, as Gareth mentioned, the evaluation of the land in the first place to see whether it's worth pursuing creation of units and credits, and right through to negotiating Section 106s with the seller's local planning authority, right through to negotiating the sales agreements between the seller and the buyer of the credits and units. So you will have legal costs, you may have other third-party costs such as those of ecologists, and don't forget your overheads. So, you know, whether it's you're a one-man band or a big operating business, you'll have some overheads, and all of those we would suggest need to come out of the share of pie before the share of the profit. So the the buyer will have paid, let's use some easy figures, £1 million for some credits, and you want to be taking your costs off that before there is a share with the landowner. But equally, the landowner may have its own Section 106 costs, allocation costs, because it will want to oversee what your lawyers have done in relation to those documents. It may have its own ecologist costs, and of course it may have costs of the creation of the units, you know, the enhancement works which create the units or credits, particularly in relation to biodiversity net gain, and then it will have its ongoing maintenance and monitoring costs for its ongoing obligations under its Section 106, or in the case of biodiversity net gain, its conservation covenant. So all of those get removed from the pie before the divvying of the profit. And then in terms of divvying of the profit, you know, we normally see that's 50-50. But, you know, last week I was giving a very similar talk to landowners, and I was saying, watch out what your intermediary, your broker can deduct before you get a share of the profit. You know, it might be 50% of dibbly squat. So, yeah, there's a lot to be done in terms of that. Next slide, please. And this is looking at the money, but from a different angle. So the flow of the money, as I mentioned, it's paid by the buyer. Now, the buyer might just pay towards the credit, pay the price for the credits or units. More and more, we're seeing that the buyer is also asked to pay a contribution towards the seller's legal costs, which could also be your legal costs and other third-party costs. And that contribution I've seen as small as £750 up to £24,000. So, you know, it's an additional cost that buyers are getting used to having passed on to them. And then, you know, going back to that pie chart, you and the landowner are deducting your costs that you've already incurred. And then the next layer down, the future costs that you're both going to have would need to be deducted, principally the land management and monitoring costs for the landowner, and for you it might be your ongoing sales and marketing costs, and then you divvy up the profit. Next slide, please. So some commercial norms and top tips. I know I've said it loads of times, but there isn't a one size fits all. Equally, when we see brokerage agreements, I've seen 3 pages and I've seen 20 pages. So, you know, there's different appetites for how much detail you want to put in that agreement, but you would always want to say certain things, such as who can conduct the negotiations. I would suggest that has to be you, otherwise you're murking the waters with buyers. Commission period, that's interesting. You know, it really depends on how fast the units are going to get created, what the market is like in that particular geography where the land is. You know, are all the units or credits going to be snapped up immediately? You know, if you've done some soft market testing, you will know what the appetite is for those units and credits before you get involved, so you know whether it's worthwhile in the first place. So would a 12-month agreement be okay? Or I've also seen where the intermediary is saying, saying to the landowner, we don't want to put all these units on the market immediately because that'll depress the price. So we're going to drip feed them, in which case you would want a longer term agreement and a longer commission period. Also, in terms of commission period, think about once the agreement comes to an end, say it is a short agreement, you might want to say, and this is quite common, well, the agreement's only a 12-month agreement, but if the seller manages to sell any units within the 6 months after that, I also want a share of that, please, because I've contributed to that, maybe by negotiating the Section 106 on the seller's behalf. Payment terms I've mentioned. Normally, you know, when we're acting for the intermediaries, we would expect the buyer to be paying the money to the intermediary. The intermediary then takes its cut and pays the balance on to the seller. So how fast are you going to do that? Is that 30 days? Is that 90 days? That's a cash flow thing. I've mentioned exclusivity. Don't forget limitation of liability. It's a contract, and therefore you need to limit your liability. Normally, you know, and again, this isn't scientific, but you would limit your liability to the sums received under the agreement. Next slide, please. And then I'm moving on to the sale agreement. So this is the sale agreement of the units and the credits themselves, which for some reason we all call allocation agreements. It's just one of these commercial norms that's grown up over the last few years. As I mentioned, in the majority of cases, the broker or the intermediary has not taken ownership. So it has no right to sell. It has a right to market, but it can't transfer title to the unit or the credit. Therefore, that allocation agreement is going to be between the landowner, the seller, and the buyer. Next slide, please. And what we typically see in these allocation agreements is that they're either a one-stage affair or a two-stage affair. So what do I mean by that? The one-stage affair is very simple. So on signature of the contract, the buyer pays the whole money for the unit or the credit, and ownership of it passes from the seller to the buyer. Job done. More usual, however, is a two-stage process because developers they're very averse to paying more money before they have to. So what they will do is at the point that they know that they're going to probably need some credits and units, they will look to enter into the allocation agreement with the seller in order to reserve them. So no ownership is passing at that stage. And because they're reserving them, what they will do is pay a deposit, and we typically see about 10%. again, you know, I've seen 5%. I don't really see more than 10% these days. Then later on, upon some trigger happening, which isn't always the same trigger, the buyer will come to the seller and say, actually, now I need them. And the point at which they need them is the point at which normally the developer wants to put a spade in the ground. So that'll be when it's normally not just got its planning permission, but has satisfied its other pre-commencement planning permission conditions, and it knows it's definitely going ahead. And at that point, it pays the balance and ownership of the units or the credits passes to it. Gareth. You've got your hand up there, Gareth.
Nope.
Okay.
Sorry.
Thought you wanted to come in. So it's normally a two-stage process. That's what we see. Sometimes developers also elect to be able to extend the reservation period. So they've paid an initial deposit, but if they want to extend that reservation period, they normally have to pay another tranche of a deposit, so a secondary deposit. And then other things we see typically in those allocation agreements is that the deposit is not refundable. There might be limited circumstances in which it's refundable. For nitrate and phosphate credits, a lot of developers would say if there's a change in law, which means we no longer have to have those in order to proceed with our development, we want our deposit back. You know, there's no right or wrong answer there. If you can resist that, fantastic. If you can't, maybe offer to pay 50% of the deposit back and not the whole amount. We've seen all types. What else is normal? The developer might also say that it wants a discretion not to buy all of the reserve credits or units, but only some of them. But that's a bit of a pain for you and the landowner because suddenly it's got a handful of credits or units to find an alternative buyer for. So again, there are commercial norms around the allocation agreement, but nothing set in stone. Next slide, please. And then finally, Gareth and I just wanted to mention land management agreements. So as the intermediary, we have seen models where the intermediary either provides the services for the initial enhancement works and or the ongoing maintenance and monitoring works, all of which are seller obligations, landowner obligations under the Section 106 or the Conservation Covenant. And I deal with them when they're simple services agreements. So the ecologist might either be providing these services itself with a service level agreement or appointing a third party to do so. Gareth, you get involved with the more complicated ones.
Yeah, that's right. Yeah, effectively, you need to make sure that, again, similar principles that the parties are bound. So if you're acting for the broker, obviously you want to make sure that if there's a change in ownership, that the parties will be bound by the ongoing relationship. And similarly, if you're acting for the landowner, you want to be able to terminate the relationship as well. So it works both ways. But again, you may need more restrictions on the title, again, to make sure that that commercial agreement can be enforced against successors.
Thank you. And what we do see is that those land management agreements are rarely as long, well, never as long as the Section 106 obligations in relation to biodiversity net gain units, nitrate credits, phosphate credits, etc., etc. So, you know, depending upon what kind of credit it is, that obligation is either 30 years, 80 years, 120 years. What we normally see is that that land management agreement is maximum 10 years because what service provider wants to enter into an 80-year agreement, you know, when they know that they won't be around. So, yeah, we see different models of that. Next slide, please. So that brings us on to questions. Just before we dive into questions, so please put any in the Q&A that you want to ask. We do have, at Freese, we do offer brokerage agreements. Obviously, we act for sellers, intermediaries and buyers in relation to Section 106's conservation covenants, allocation agreements, all the rest of it. If you'd like a little freebie as a result of this morning, then we do have a brokerage agreement questionnaire that we can send you. And then we have one question this morning from Michael. At what point does a broker need to be FCA regulated under different arrangements? You don't necessarily have to be FCA regulated at all. I would say most brokers aren't FCA regulated because their business isn't of that nature. The ones where we see that they do need to be FCA regulated is where they're going off perhaps to get other investors. So we have seen models on the more complicated end of the spectrum, where people are creating special purpose vehicles for individual pieces of land, putting the arrangements around that land, and then they're able to package it up and sell that to investors. And then you definitely would need to be not only FCA regulated, but behave in accordance with all of those rules. So I can't see that we've got any other questions this morning, but all of our details are on that final slide. Do feel free to get in touch with us. Please can we add the link to the other webpage on the chat? It's on the website, and when Tom sends out links with the slides, etc., he will be sending out links to the web page, which has got the links to all the previous recordings on it as well. So another question has just come in, also from Michael. What about I can't answer that one. So Michael,
I don't think that's possible. I mean, I'm looking at that question. So what about a situation where a single legal entity forms a collective of landowners to sell units on behalf of them? Can a 106 be arranged with the SLE? I think that's highly unlikely, because in both cases, whether it's a conservation covenant or a 106, it's basically a promise by the owner of the land. So there needs to be, it might be possible for the SLE to covenant, and for the underlying landowners to sort of support that covenant so that they're backups if the original covenant, if the SLE was not able to honour its promises. But I don't think it would be acceptable to have no involvement in that agreement by the landowners themselves. I think, Gareth, you're nodding at the same time.
That's right. I think you'd have to have all the landowners would have to be a party to it, but the single legal entity could be a party to contractual position.
Yeah. Hope that helps, Michael. But let us know if you have more questions.
Yeah.
So I think there's one.
Yeah,
more.
he said it's really useful. Great. Okay.
So email us if you want a copy of the brokerage questionnaire. Certainly email us if you've got any other questions you want to put to us. As I say, all our email addresses are there. Penny, shall I hand back to you to close?
Yeah, thanks very much, everybody. Really pleased that you've all attended, and thanks to the speakers today. And like Kirsten said, yeah, we're always here to answer quick questions. We don't charge for initial inquiries. Please feel free to contact us. Of course, we would like to do some big jobs for you as well, but the initial inquiries are always for free. So thank you. Have a good day.
Everyone.
Bye.